My name is Eric Siegel, and this is Jordan Belfort and stock market fraud. Now, this is an interesting topic, but the real reason I'm discussing stock market fraud is because just about every one of us is or will be involved in the stock market at some point in our lives, and we need to be able to know how to protect ourselves. First, I'll give you some background on stock market fraud, which is also known as securities fraud. Most victims are people age 50 and older. From 2006 to 2007, class action securities fraud lawsuits nearly doubled. Since 2010, more than 100 enforcement actions against about 200 individuals and 250 entities have been carried out by the SEC. And the graph on the right shows the amount of securities fraud cases the SEC took in each of those respective years. So, what is securities fraud? Securities fraud, or stock market fraud, is a deceptive practice in the stock or commodities market that induces investors to make purchases or sales based on false information, which usually result in losses. Now, there are three types of securities fraud. The first is fraud by the company itself, which occurs when an officer or director of a corporation doesn't accurately report the company's financial information to its shareholders. An example of this can be seen in the Enron scandal of 2001. The second kind of securities fraud is insider trading. Insider trading occurs when someone with confidential information about a company's financial state uses that information to make decisions about whether to buy or sell a stock. The third kind of securities fraud is third-party misrepresentation, which occurs when a third party gives out false information about the stock of a particular company. Securities fraud today. When I think of securities fraud, I think of the Enron scandal of 2001 or the WorldCom fraud of 2002 and think securities fraud is, for the most part, in the past. However, as you can see from this slide, securities fraud is still very prevalent, which is why this topic is so important. So what is protecting us from being a victim? The first is the Securities Act of 1933. Which was enacted following the stock market crash in 1929. It had two main goals. The first goal was to ensure the transparency of financial statements, meaning investors or buyers of securities receive complete and accurate information about a company's financial situation. The second goal was to establish laws against misrepresentation and fraudulent activities. This information is all included in a registration statement known as the prospectus, and anyone, meaning the company or individuals signing this statement, are strictly liable for any inaccurate information. The second legislation that is protecting us is the Securities Exchange Act of 1934. It established the Securities Exchange Commission, which is tasked with enforcing any securities-related statutes or laws, and their powers include ability to sanction, fine, and discipline any fraudster, and it primarily regulates transactions between brokerage firms and their clients. So, are we truly protected? A law review from the Duke Law Journal illustrates that the purpose of imposing liability for stock fraud is to warrant investors that the markets are reasonably free of cheating. Anything that requires investing a large amount of money should be more than reasonably free of cheating. Another law review I read discusses a victim's ability to get back what they lost. In a typical securities frauds case, plaintiffs consist of investors who buy stock before the price falls. Once the truth about the stock comes out, the price falls and they lose their money. Only the buyers have standing to sue. The holders have no claim. The problem with this is that most buyers are holders as well. So plaintiffs will lose more money as holders than gain as buyers, which means there's really no way for investors to get back what they lost. One example of securities fraud is the fraud committed by Jordan Belfort and his brokerage firm Stratton Oakmont Incorporated. I'm sure many of you have seen The Wolf of Wall Street, so some of you may be familiar with this. Jordan Belfort and his employees used the pump and dump scheme, which I'll talk about later in this presentation. So The SEC began investigating Belfort and his firm in 1992 for money laundering and securities fraud. This led to the shutdown of Stratton Oakmont in 1996. In the end, investors lost $200 million. Jordan Belfort pled guilty to money laundering and securities fraud and received 22 months in prison and has to pay back $100 million. So the pump and dump scheme begins with the stock promoters loading up stock of a microcap or penny stock company. The promoters then inflate the price of that stock by disclosing false information about the company and claiming that huge price gains will follow. When the stock price increases, the promoters continue to pump the stock while selling or dumping their own stock. Eventually, the stock price falls, and the people who bought the stock lose all their money. There are a few signs that you can use to determine if there's a pump and dump scheme going on. And the first is if a promoter claims the stock to be the next hot thing, or a promoter claims to have inside information about a company. Usually that promoter or that company is committing pump and dump. Another would be if there's a surge in the trade, or a huge surge in the trading of a microcap stock without public news, and if a promoter predicts a huge return on a stock, such as 10K could turn into 25K in 30 days. You should always use caution when taking advice from people you don't know. Investors should conduct their own research or consult their investment advisors before purchasing a stock. So, in conclusion, the Securities Acts of 1933 and 1934 certainly offer us a bit of protection. However, if you are a victim of fraud, it's almost impossible to get your money back. So the best protection we have is to educate ourselves on this topic. And before you purchase a stock, make sure you have done your research first.